Hi, everybody. How are you today? Good to see you. Any questions before we begin today's discussion? Nothing. Okay, fantastic. Let's see that. So today's discussion, I'm going to find my notes, otherwise I won't be getting anywhere. Contingency and contingency removal. So there are different questions I think that come up throughout a transaction regarding contingency removal. So some of the questions that I come across: what happens when the buyer doesn't remove a contingency in writing at the end of the contingency period? We're going to go through that. What can a seller do if at the end of the contingency period, the buyer doesn't remove the contingency in writing? So what happens if a buyer removes all contingencies and discovers a material defect in the property prior to the close of escrow and wants to cancel? Good morning, Dandan. What exactly is the rule for cancellation based upon the inspection contingency, and is a buyer guaranteed to get the deposit back? So we're going to entertain all those interesting and fun facts. So what is a contingency? It just provides a party to the contract the ability to condition performance on the occurrence or non-occurrence of event. So that means I'll close escrow if you do these various things, Mr. Seller. That's really what we're saying. And then paragraph 8 or section 8 of the RPA, you'll see all, if you wouldn't mind pulling up, Carlos, all of the contingencies, the default contingencies in the contract located in section 8 of the purchase contract. So if you, and it should be simplifying your life if you have to read the various contingencies, but that does not mean you cannot create your own contingencies also. Now, where is it? There it is. All the contingencies are found in section 8 of the RPA. And we'll go through some of those. Let's see. And then those contingencies are for loans, approval, appraisal, investigation of property, review of seller documents, the prelim and the common interest disclosures, review of leased or lien items, and the sale of the buyer's property if they attach form COP. So remember, a buyer can make an offer conditioned upon the sale of their existing home. So additional contingencies. So you can actually create your own contingencies. What if somebody signs the purchase contract and maybe they condition the contract upon the approval of 5 other beneficiaries of a property? So that could be a contingency, for example. Or you can make it contingent upon finding or selling your existing home. And then there is an inspection contingency. If we go back to the grid, please. And it's section 3L3. Not scrolling that well, is it?
I just had to move this down so I can just hit the pages. Where's the pages?
What was there?
This where you want to go?
3L3, please. Under section 3. There we are. Okay. So you can see the different contingencies are all under section L. Those are the default contingencies. And if you're looking at that, you can see it also references the paragraphs in the RPA if you need to reference that. So every single one of those is going to be found under section 8. So can a buyer waive an inspection contingency? Anybody tell me? Of course, there's no California law that prevents a buyer from waiving their inspection contingency. So they can do that. That still doesn't mean that your obligation to disclose anything you know is negated. So you still have to provide all the disclosures, and the seller also has to provide all information regarding to deficiencies in the property. And of course, the loan contingency is found in paragraph 3J2. And then it's really highly suggested that you fill out the information associated with the financing. Could you go to page 1 of the RPA, please?
Page what?
1 of the RPA.
Sure.
And then down so we can see the financing. That's good. All right. So if we were to have a loan amount, we would actually insert it here, but we should always put a maximum interest rate in here, and we should always actually, you don't have to fill in the points. You can allow that to remain blank. So remember, fill in the interest rate as a cap. So if today's rates are 6.5, insert 7% there. It could be a reason for the buyer to cancel the contract successfully. And then the appraisal contingency, what is that? If the appraised value does not come in at the purchase price or higher, then of course the buyer can cancel or the buyer can renegotiate. So that's a good possibility. What happens if the square footage in the appraisal is lower or less than what the buyer was led to believe? Can you cancel based upon the appraisal contingency?
No.
Absolutely not. Very good answer, Carlos. So no, if the square footage is different in the appraisal, that's part of the investigation contingency. So when canceling a contract, everybody's going to focus on the references you make when canceling to contest whether or not they're going to release the money back to the buyer. And then if we go to section 3L2, I haven't seen this used very often, but 3L2 talks about the appraisal contingency. So if we make an offer for $1 million, we can say to the buyer or seller that we're really interested in the property. So we can assert a value of 950,000 here. And just as long as the appraisal comes in at 950,000 or greater, even though I'm paying $1 million, the buyer cannot cancel based upon the appraisal contingency. Then non-optional contingencies. If it's built before January 1st of 1978, there is a lead-based hazards contingency and disclosure that's required. And the buyer has 10 days statutorily to investigate the property after execution of the contract. Well, how can you overcome that? You can give them the opportunity to inspect the property before the purchase contract is executed, for example. So that's a way to overcome that mandatory non-waivable 10-day period for the buyer after the contract is executed. So another or other non-optional disclosures, the transfer disclosure statement, unless you're exempt. So you must give the transfer disclosure statement. There are very few exemptions in which the seller is not obligated to provide a TDS. And then the actual aspect of that, the TDS does a couple of things. It's upon receipt, there's a 3 to 5 day rate of rescission for the buyer that's granted them. 3 days if I hand it to you, 5 days if delivered electronically, for example. So theoretically, the buyer finds something in that transfer disclosure statement that is not acceptable to them, they can cancel. As a matter of fact, the TDS doesn't even state that. It just says subsequent to receipt of this document, the buyer has a right of rescission. It doesn't say there must be a reason, but there should be a reason if somebody's going to be canceling. And then in regards to the TDS, how strong is the aspect of that? So there's one example in which a property individual is leasing the residential portion of a commercial building, so mixed use, lived there for 2 years. And then just before the close of escrow, the seller failed to give the buyer a TDS. The buyer was able to successfully cancel. So that is the power of the TDS. Non-delivery, because we have people sometimes will say, I don't want to give a TDS, or maybe I think I'm exempt.
So when canceling, is it better to specify just the reference paragraph or a specific reason?
If we're canceling, we would specify the paragraphs. We'd specify paragraphs 14 and 8.
No matter how hard the other agent says, I need a reason.
No matter how hard. And Kimberly Norton, she's online. This just happened to her, as a matter of fact. And we had valid reasons for cancellation, and none of the contingencies were released. And then, of course, I think it was just the agent, not the seller, who was being obstinate in terms of releasing the deposit, but they did release the deposit. And even in that case, it was interesting. If you look at Megan's Law, if you look at the website, it's amazing how many pedophiles and sex molesters are in the area. So that is a valid reason for canceling a contract. And for this particular property that Kimberly was representing the buyer on, the little marker was right on top of the address, just about, for somebody who was a child sex offender having pornography associated with children. And then the other agent still said, oh, you need to put that in writing. Well, we don't need to put that in writing. You just better be prepared if they do contest it.
So just reference the section on the contract.
Section 14 and 8, and I would just ask that you contact us if you're ever canceling a contract when you're representing a buyer or a seller. Don't cancel anything.
Can I ask one question?
Of course.
In reference to the TDS, so if we have a seller exempt disclosure, it is not required. That's one of these exemption times, correct?
Well, if the TDS is required, the seller property questionnaire is required. If the TDS is not required, then the exempt seller disclosure would be required. If that answers your question.
Okay, thank you.
Okay, great. And then someone tell me one exemption to the TDS? Are investors exempt?
No.
No, very good, okay. So the only example I can think of typically is if a bank-owned property, they're exempt from providing a TDS. If there is a public report available in a traditional new housing tract, or if the seller is a beneficiary of the decedent's trust or estate, and they never occupy the property during the year following the decedent's death. So that could be an exemption also. So it's rare. If there's a corporation, LLC that owns a property, they're not exempt. And unless it's, there's certain circumstances, even if it's a sale associated with someone's death, it still doesn't mean that they're necessarily exempt. There could be exemptions. And then how are contingencies removed? Well, it's through a contingency removal form. So it requires active removal. You must sign the contingency removal form. Commercial contracts have passive removal after the passage of time. If you don't contest the area of the contingency, then the contingency will be removed. So if you're ever engaged in something other than the car contracts, be careful of the contingency period. All car contracts have an active removal contingency period or time frame. So what if a seller doesn't deliver the required disclosures? Does a buyer, or is the buyer obligated to remove contingencies for that seller related disclosure? The answer is no. So if they don't deliver the disclosures as required contractually, the buyer has no obligation to remove those contingencies. So what if the end of the 17-day contingency period expires, the seller still hasn't delivered those disclosures? Must the buyer remove the contingency? And the answer is no. Then if the seller threatens to cancel, I would say they probably would be in breach of contract because they haven't fulfilled their obligations. Then other questions about the contingency period, and it'll probably be repetitive as we go through some of this. There's only one area of the purchase contract that references this in any addenda, so on and so forth, but the contingency period is going to be equal to the greater of the contingency period stated under section 3L, right? So for the default, they're all 17 days, or 5 days following receipt of the required seller disclosures. And there's an exception to that. The seller disclosures aren't delivered in the first 7 days, and only does that 5-day time frame apply. And the only place you'll find that language is under section 14 of the contract. Show some examples. So if the contingency period ended on Wednesday, July 7th, but the seller gave the buyer a seller property questionnaire, and that's a seller mandated disclosure, right? 2 days later on the 9th, then the buyer has how many days from the 9th to remove contingencies? Well, they were given the disclosures. Even though period ended on the 7th, they were given the disclosures on the 9th. So 5 days thereafter, that's the time frame they have through the 14th at 11:59 p.m. to remove those contingencies. And what happens in that example if the disclosures are finally delivered on a Wednesday? No, let's back it up. Tuesday. So that was the 19th day. The buyer has 5 days after that. So they're delivered on Tuesday. 5 days later falls on a Sunday, right? Wednesday, Thursday, Friday, Saturday, Sunday. If the 5th day, the execution of the event, falls on a weekend or legal holiday, it then falls to the following business day. And if Monday were a holiday, it would fall to Tuesday before the buyer is obligated to remove those contingencies. So that's very important. And also the same thing applies for the initial deposit. Remember, it's 3 days after execution, 3 business days for the buyer to deposit their money. And then does the 5-day rule apply to a preliminary title report? And the answer is yes, because that's a seller required disclosure. Just like them filling out the transfer disclosure statement, right? That's a seller required disclosure.
HOA docs too, right?
Yes, as a matter of fact, HOA docs too. So what happens if the buyer doesn't remove contingencies at the end of the contingency period? Well, the contingency lives on. So the only thing the seller can do is serve notice to perform to remove those contingencies. And the default language in the contract is that following the date of receipt, the buyer has 2 more days in which to comply with that demand. So if I deliver a notice to perform on Wednesday, then the buyer has to close it Friday to remove those contingencies, for example, and the seller could cancel on Sunday if I don't. But if they don't serve you with a notice to perform, the contingency lives on. And then how soon can a seller give a notice to perform? Anybody want to answer that one? Go ahead, Carlos. Go ahead. Oh.
2 days before
Mhm.
the time that you did.
That's right. So you can deliver a notice to perform no sooner than 2 days before the execution of the event. So if the 17th day falls on Wednesday, you can deliver the notice to perform no sooner than Monday. If you deliver it on Sunday, 3 days before, it's considered defective and you would have to resend the notice to perform. So what happens if sometimes we'll see different contingency periods throughout. So maybe it's 15 days for loan, 10 days for appraisal, 5 days inspection. So if I send, let's assume my investigation contingency is 5 days. So on day 3, I send out a notice to perform to remove all contingencies.
It's defective.
What's interesting in the contract, it says only those items to which the time frame is applicable is valid. Everything else is defective. So if all those other contingency periods fall at a later date, at least you're right in serving them with that notice for the investigation contingency. Strange.
Yeah.
But and then this closing escrow contingency of the contract, no, it is not. It's a contractual covenant. It's an obligation. So if for some reason all parties have removed all contingencies and it's going forward and one of the parties refuses to close, we would give them something called a demand to close escrow. And that can be served no sooner than 3 days before the close of escrow.
How common is that? Have you seen that?
It's happened. It's not very often, but it does happen. We never want to give them a notice to perform because if you give a notice to perform to close escrow, the language in the contract states that the seller shall return the deposit. So we don't want to put ourselves in that kind of a position that there may be an obligation. In that example, if the seller cancels after giving a notice to perform, may have to release the deposit. And then questions. So what happens if a buyer removes all contingencies and discovers a material defect in the property prior to the close of escrow, wants to cancel? Well, the question really is, can the buyer cancel without being in breach of contract? The buyer can always cancel. So that's really what it comes down to in terms of the issues. So I think I've got some examples here.
How did the buyer come by the information?
How did the buyer? Very good. So I had some examples here. So if in the event buyer has removed all contingencies and the seller has or the buyer obtains another third-party report that says that there's a crack in the foundation, can the buyer cancel based upon the information found in that third-party report? Would it open up the rescission period? And the answer would be no. If the seller realized that they gave disclosures and the disclosures were incorrect after the buyer removed contingencies, and the seller modified those seller disclosures, then yes, if the seller modifies it in something material, the buyer theoretically could cancel it and obtain their money. So what if there's a defect and nobody noticed it until the verification of property condition? Well, and it was an obvious defect, it's likely the buyer would lose their deposit if they refuse to close escrow, unless you can somehow show that the seller negligently or intentionally did not disclose that information. So it's a nightmare when it comes down to it, once contingencies are removed. And then, yes, what's that?
So they remove all the contingencies as a buyer, and later on when they do the final walkthrough and then find something like a major issue. So if that's buyer can cancel it.
Well, was that issue noticeable to a reasonable person before they remove contingencies? So the answer is yes. Either they saw the big crack in the floor. Let's assume they saw the crack in the floor and everybody is aware of it. Then it comes down to the close of escrow. Then I would say at that point in time, if the buyer cancels, they're going to be in breach of contract. They can't, if it's visible to a reasonable person it's not a valid reason for cancellation, because if there's a big crack in the sidewalk, they're stepping over it every single day. So that would not be a valid reason.
But if there was a big area rug in the living room and then
And
they
this, right?
removed it, then the final walkthrough shows
They
it.
found it,
Yeah.
and then the question would be, was the seller aware? Did the seller intentionally hide that defect?
That's what that rug was for.
Yeah, so that's what the rug was for, exactly. We never had a rug there before. So those are questions that have to be answered. And that's, yes,
Yeah, my question is, I totally understand your point,
Mhm.
because if they're hiding something, that would totally different things, because they should disclose on DPS or SPQ, right?
yes.
So my question for you is, when they did home inspection, everything's fine, and then they remove contingency. What about if later on, just saying, just like scenario is, like, they find the water pipe, broke,
Mhm.
and then the water's all over the place, and then seller, they don't want it. Can they, they can cancel it or?
Well, if the water pipe breaks after all contingencies have been removed, and then the seller then discloses that to the buyer, then that would open up the so-called rescission period and give the buyer up to 5 days thereafter to cancel. However, if the pipe broke, let's say the seller's out of town and the buyer had the opportunity to come in and perform their final inspection, and they discovered it, it may not be a valid reason for cancellation by the buyer. Because there's no what happens if the seller amends the disclosure after removing contingencies? The contract talks about the rescission period. If the buyer amends the disclosure and it's a material amendment, suddenly now and they give that information to the buyer, it's telling the buyer, okay, I made a mistake or this happened. That gives them, the contract then gives the buyer the right to rescind the contract. But the way the contract is written, if the buyer discovers it, whether it's from the buyer's own investigation after removing contingencies, or through a third-party report that the buyer paid for or the seller provided, theoretically, the buyer may not be able to cancel without being a breach of contract.
So the
So-
buyer walks in and the house is flooded in the final walkthrough. That's not,
It's going to be a fight,
Yeah.
but that's exactly what the
Wow.
contract is defining. So I think when it comes down to a cancellation, we want to be very careful about what we're doing or what we're telling the other party. We don't want to go in and say that crack that was 12 inches wide, which everybody saw, now suddenly we want to cancel based upon that, because they are then going to contest that.
Excuse me.
Yes.
When it comes to the date of the removing the contingency, sometimes the agents just sell you the notice of the performance.
Yeah.
Because, so just that give you a time to due date. But in the case that, I understand that at that time, they have to, by the law, they have to send back their deposits if it doesn't happen within that period of a time. So does the seller know that they do that? Or does the seller should be informed that? they
That a
must
notice of
send
perform is
the
being
notice
sent,
of-
the seller has to sign it. The seller has to sign the notice of perform. Yes, so they should be aware.
So they have to explain it that if they don't do it until this date.
Well, the notice of perform is just telling the buyer, for example, to remove their contingencies, and if they don't, the seller can cancel.
it doesn't mean the seller's going to cancel, but it's telling them that the seller
They
can
now
cancel.
have the right once those 2 days expire. Yeah, it doesn't mean they're going to cancel.
Oh, so it doesn't mean that in a black and white, it should get.
It's
done.
not, but it's telling you, we now have cancellation rights once you receive this and 2 days later.
And it's also, if you're representing the seller, you're protecting your seller. So
Yes, you are. And then what happens if you're representing the seller, you deliver a notice to perform, and then a month passes? Could the seller suddenly cancel then? Well, I think you better send another notice to perform, because the contract uses the term time is of the essence. If I send a notice to perform and I wait for a month to cancel, obviously time was not of the essence to you. Let's see. And then why can a buyer cancel based on loan contingency? Well, if the buyer's, there's a couple of things. So we're saying in our example, it's a purchase of $1 million. I'm putting $200,000 down. I'm financing 800,000. Buyer better be pursuing the financing for $800,000. If they pursue financing other than that, and they're denied the financing, it may not be a valid reason for canceling based upon the loan contingency.
So it has to be exactly the same amount.
They better, right?
How do they get notified?
What do you mean? Who get notified?
Say that unfortunately their loan didn't go through.
Well,
So how should I mean, is this something that they have to disclose to seller based on what?
no, but I'm going to ask for the declination letter issued by the lender. I don't want your information. I want it from a third party that declined the loan. So the declination letter is going to spell out at least the basics, give them sufficient information to make a determination whether they breach the contract or not. Let's see. 10:26. Oh, I've got a lot of time. And then canceling on the investigation contingency. One little item probably is not good faith cancellation. So be sure that you have multiple reasons. If you're giving consideration to your client canceling the contract, they don't have to disclose those reasons, but they should be prepared to defend that. And as Carlos brought up before, you don't have to specify the reason for cancellation. We would simply specify paragraphs 8 and 14 of the RPA. Remember, section 8 is all inclusive of all contingencies. Let's see. And then would you pull up the contingency removal form? So I just wanted to go through some of these items with you. Some of them are very well self-explanatory. So section 2A, the loan is a loan contingency. If the buyer can't get the loan they specify in the purchase contract, then theoretically they can exercise their right to cancel based upon the loan contingency. The appraisal is somewhat self-explanatory. It just, the opinion of value must equal or exceed the purchase price. And in the event it doesn't, the buyer can cancel or the buyer can renegotiate the price. And remember, in the purchase contract, the buyer is obligated to give all reports to the seller. And that lives on beyond determination of the contract, even if it fails. But that's not true of an appraisal. That's an opinion of value. It's not considered a report. But in this specific case, the seller could ask for a copy of the appraisal if we're canceling based upon the appraisal contingency. So don't think you can get away with anything. And then section 2C1, entire buyer's investigation. Well, it's broken down. Well, what does that mean exactly? Are the seller's disclosures included in the entire buyer's investigation? It's not. It's actually separate and distinct. So section 2C1, it's broken down, you can see, in 2C2. Only part of the investigation related to inspections concerning physical attributes of the property. And then section 2C3, all buyer investigations. So what else could that mean? Not just insurability, maybe the neighborhood itself. Maybe there's aspects of the neighborhood you don't like, or maybe the schools, for example. That's part of the non-physical aspects of the investigation.
These damn pedophiles, huh?
Are they? Well, that's a problem, isn't it? Yes, that is a problem, right?
That the information that is that has to send it to us.
Yes. So if they don't, remember, then that extends your contingency period. And then 2C4, right? So it breaks down. You can even create exceptions. I remove everything excluding these things. And then review of seller documents. Let's go through that. It's pretty extensive, as a matter of fact. So it's referring to paragraphs, as you can see, 304, 8D, 9B6, 10A, and 11. What does that encompass? The TDS, the natural hazard report, the seller property questionnaire, or exempt seller disclosure if you're exempt, the seller is exempt from providing a TDS. The AVID. So that's part of proper delivery of all the seller disclosures. Lead disclosures, remember, there's a 10-day period in which the buyer has the opportunity to inspect the property if it's a pre-1978 property, and it cannot be waived. Home fire hardening, defensible space advisory also, come on in. Withholding taxes. So Foreign Investment and Rural Property Tax Act, remember in that specific case, the buyer has an obligation to obtain the tax ID, or at least through a qualified substitute, obtain the tax ID, make a determination of whether or not that seller is subject to backup withholding. If the seller is a non-resident alien, the seller is likely subject to have money withheld from the sale, right? Backup withholding. If it's over $1 million sale price, it's 15% federal and 3 1/3% state. And that's of the gross selling price. So let's continue with that. So what else? And then common interest disclosures also. So that's all, that's broken out separately. Common interest disclosures, escrow typically will order those. So that's going to include a number of things, obviously, CC&Rs, the rules and regulations. But all of these items are required of the seller in terms of delivery of the disclosures. So including, so we said common interest disclosures, review of lease or lien items. All of these items fall within the 7-day time frame that the seller is obligated to deliver the seller disclosures. And why is that important to us once again? Because this refers to the contingencies. If the seller doesn't deliver those seller required disclosures within the first 7 days, then the contingency period could be longer. It's going to be equal to the default time frame, that or 5 days following delivery of the seller required disclosure. So you can see there is a lot of information that should be provided you, and you should stay on top of that. Especially when you're a listing agent, you want to deliver that as quickly as possible and put the pressure on them. So I think that's all I have for today. Anybody have any questions? Yeah, we've got one question. All right.
I remember, so we, I forgot what's the name of it. You know, we asked them to close escrow on time. So we can give them kind of a notice to perform, right? That would be like 3 days before the closing date. Is that count for holiday, SRS, Sunday too, right?
If you give it 3 days before the closing date.
But
So the
that counts Saturday and Sunday, if you're Saturday and Sunday.
Yes, it does. So the 3 days include it when you're counting, would include Saturdays, Sundays, and legal holidays. But if the third day falls on Saturday, Sunday, or legal holiday, it then falls to the following business day in regards to when the effective date of that is. And I am not quite done yet. Sorry, everybody. Would you bring up section 14 of the purchase contract, please? Sure. Thank you. Okay, we're there.
Yes.
Thank you very much. So in regards to contingencies and timeframes and removal of contingencies, paragraph 14 addresses mainly everything for us. So it talks about all these different areas of the contract under section 14A, pinning the responsibility on the seller for delivery of those disclosures. And remember, it's subject to the rule 5 days following delivery, or that or the greater of between that and the actual contingency period found in the grid under section 3L. Let's see. And then if the buyer asks for repairs, must the seller respond? And the answer is no. So there's no obligation. And then we talked about this 5-day rule. You'll find this under paragraph or section 14B3. It states on the second line, however, if any report, disclosure, information for which seller is responsible is not delivered within the time frame specified in paragraph 3N1, and that's 7 days, by the way, then the buyer has 7 days after delivery, has 5 days after delivery of any such items or the time specified. So all it's saying is, and this is the only area of the contract you'll find it, if the buyer or seller doesn't deliver those disclosures in the first 7 days, then the contingency period is equal to the default time frame found under section 3L or 5 days following receipt of those disclosures. Then it also talks about buyer right to or seller right to cancel. And remember, the seller can cancel, for example, based upon non-delivery of the buyer's initial deposit, but they must always give a notice to perform before canceling. And we also talk about sellers or buyers' right to cancel, seller contingencies. So if the seller has a contingency for the sale of their existing home, then there's a time frame in which they must remove that contingency. And under section E, we've discussed this already. It talks about notice to buyer or seller to perform. In this paragraph, it talks about they're given at least 2 days following receipt of the notice to perform, but in no case must the other party perform any sooner than the time frame found in the contract. And we also talk about demand to close escrow 3 days prior to the scheduled performance date. And then effective cancellation on deposits. There is no obligation, there's no assurance the buyer is ever going to get their deposit back, but theoretically, they would have to mediate and maybe arbitrate if all the parties agree to that. And possibly the buyer may be entitled to $1,000 fee assessed against the seller if the seller acted unreasonably. That never seems to deter anybody, though. A whole threat of $1,000 doesn't seem like that much money anymore.
What are your recommendations on you're representing the seller and giving a notice to buyer to perform to remove contingencies versus not doing it and just doing it after the 17th day?
I think, I don't know if everyone heard Carlos's question. Should we or should we not give the buyer a notice to perform from the seller? I think it's just a matter of the transaction. Can you tell if they're being earnest? Is the other agent ignoring you, trying to hide? I think that would drive me to make my decision. I probably, at least we've witnessed a lot of cases. From my own personal perspective, I would be willing to give a buyer a couple of extra days. I wouldn't object to that if they can give me evidence that they're making a good faith effort.
Because an issue can arise later on down the transaction where the seller is hurt somehow from the transaction, and they can come back and say, well, you didn't have my best interest in mind. You didn't do what you're supposed to do.
Yeah, I think you have to tell the seller.
Yeah.
And the seller should be making that decision. Ultimately, they're going to ask you for what do you think we should be doing? But then the other thing just happened recently on San Sebastian. The buyer, and it's closing a couple of days late, but the buyer made really aggressive or submitted really aggressive terms, and they're highest price too. But they probably knew that they couldn't get the loan approval within that specific period of time. So if you think that someone's really giving you really aggressive times and they can't live up to it, maybe you give consideration to a notice to perform. Certainly tell them, if I don't get the contingencies removed, we are sending out a notice to perform.
After someone would come, their appraisal, that just to see that, if anything wrong with the investigation.
Mm-hmm.
To come
A fiscal inspection or?
inspection.
Okay.
Thank you.
Okay.
So, and they receive the report and they say, I want to cancel it, and they cancel it.
Well, I'd say if someone did a physical inspection, they're dissatisfied with the property condition, yes, they can cancel. If they're saying it's based upon the property condition
Yeah,
and it's not satisfactory,
yeah,
you can. Even if the seller's willing to repair those deficiencies, they still can cancel.
they can.
Yeah. If they're saying there's a scratch on the door, that's what we found on the report, I would say, I would question that and say they're not canceling in good faith, right? So.
Yeah, but again, might be even very minor, but they can't say. I want
Well, yeah, I think it's, I guess it depends what the market is. Sometimes sellers don't mind about the cancellation. They have another buyer. But if it's really just a nominal thing, it's probably not the real reason for canceling.
And how many days after that they should send the deposit back?
Well, that's a good question. There is no time frame that's specified contractually. So we would like to think they'd like to release it right away. So remember, if the seller contests the release of the buyer's deposit, the seller should disclose to the subsequent buyer, if there is one, that seller canceled and there's a dispute over who's entitled to the funds deposited previously. It should put the buyer on notice that there's a problem here. So what if the seller, I think we talked about it, I know we have, if the seller canceled and they actually breached the contract, well, that other buyer, the former buyer, could enforce the sale. So it should give the next buyer, we want to give the following buyer notice to be sure that they're aware at least of what's taking place, so they don't come back to us and say we never disclosed that. Did that answer your question? No?
So it's not any timeline.
No, there is no time frame, and people get nervous. So obviously you want to ask them to do it. You can't, the only thing you can do to force it is to demand mediation if they're refusing to comply, or if it's 10,000, I think it's what? Small claims is now 12,500. An exemption would be a small claims action. You could then file in small claims court as the buyer. Other than that, demand mediation, and each party has to split the cost of mediation.
I put an offer in a house and it went to escrow. And then 2 days after that, I decided it's not what I want. But it was just based on an inspection. I said, based on this, I want to cancel it.
We would never say that. We would say paragraphs 14 and 8 of the RPA. That refers to all the contingencies. So we would never tell them.
Yeah, I wasn't an agent at that time.
Uh-huh.
I was a buyer.
Oh, I thought that was a hypothetical.
Yeah. But it took a while,
Mm-hmm.
so I called the owner
Yeah.
because of my deposit.
Uh-huh.
So it's just, I went, so if you are a buyer, you can not get in touch with the other buyer, the seller.
Well, no, there's nothing that stops you. I would prefer that they don't, but hey, if somebody wants to contact the other principal, there's nothing that stops them from doing that. Absolutely.
I just want to confirm something, if I remember it correctly. So let's say we send out the notice to perform, and then after 2 days, I know that the day you send it out doesn't come the 2 following days, right?
Correct.
And then after that, they still didn't remove the contingency. So now it's a seller's call, right? Seller can either wait for the buyer, maybe still doing something with the loan, or seller can cancel it anytime, right?
Yes,
There's no
correct.
any like a time frame or anything.
There is no time frame then. I was just suggesting a reasonableness, because if you wait a month to cancel, you might consider sending another notice of perform. They might say, hey, you weren't serious the first time. Anyone else? No? Okay. Well, thanks for coming today, everybody. Appreciate
An
it.
agent was asking about, if we do wants and needs through office meetings, and I said.
Oh,
"We've done
yeah.
them Before, but we
Sure.
haven't done them in a while. But I don't know if anyone will. Anything now?
Would anybody like to tell us if they have any wants and needs? Sorry about that. Listings you want to share? Buyers with a lot of money?
No buyers.
I'll be available for open houses.
Okay, that was Kimberly.
Excuse me, I didn't know how
Yes.
to complete the form that is for the photograph for the, from another agent.
Okay,
Can I come to the?
sure. I'll give it a try. I've never done a ladder. So,
Yeah, I've got buyers for, Preston Legacy brand new condos in Flight area and, Central Park West. Whoever is,
how much are they willing to spend?
to 1.5,
Yeah, up to 1.5 million. Okay.
Yeah. Any condos, at least 3 bedrooms, so that's.
That was Masood speaking.
Thank you. For
Great. Thank you. Anyone else? No? Okay. Thank you, everyone.
Wow, they have to
Hi,
remember.
thank you.
So Rich, like close like the concert